and the defendant at the bar according to the law and the evidence, so help you God.
Yes.
Thank you. Please be seated. Members of the jury, hearken to this indictment. Norfolk Superior Court Criminal Action Number 2082CR 00138, Offense 1, charging murder in the first degree. Commonwealth of Massachusetts, Norfolk to wit, at the Superior Court begun and holden at Dedham, within and for the County of Norfolk, on the 5th Wednesday of July 2020, the jurors for the Commonwealth of Massachusetts on their oath present that Ingolf Tuerk of Dover in the County of Norfolk, on or about and between May 14th and 15th of 2020, at Dover in the County of Norfolk, did assault and beat Kathleen McLean with intent to murder such person, and by such assault and battery did kill and murder the said Kathleen McLean in violation of Massachusetts General Laws, Chapter 265, Section 1. To this indictment, the defendant at the bar pleads not guilty, and for trial places himself upon the country, which country you are. You are sworn to try the issues. If he is guilty, you will say so. If he is not guilty, you will say so and no more. Members of the jury, hearken to your evidence.
Okay, so jurors, you'll be responsible for deciding this case. Please pay close attention to the evidence you will see and hear during this trial. When the evidence is complete, I will explain the legal rules that you must apply to decide this case. You'll then meet together in private to consider the evidence, apply those rules, and work together to reach a verdict. Before we start the trial itself, I'll give you some initial instructions. I'll explain the indictment that the clerk just read out loud and describe what will happen during the trial. I will then explain my role as the judge, the lawyer's role, and your role as jurors. I will discuss some of the legal rules that apply in this case, and I'll explain some important things that you must do and that you must not do during this trial. You may have noticed there is a camera in the courtroom. Please know the cameraman is not permitted to show any juror at any time during the trial. That is, the cameraman is prohibited from broadcasting or recording any images of jurors. I suggest that you ignore the camera and not let it distract you. A moment ago, Ms. Sandel read the language of the indictment in this case. An indictment is a legal document that formally accuses someone of a crime. In less formal terms, the indictment in this case charges the defendant with committing murder. The indictment is not evidence in this case, and the fact that the defendant is facing this charge does not mean that he is guilty of committing any crime. An indictment is merely a piece of paper that formally charges someone to get them to trial in the Superior Court. As I told you when we were choosing our jurors, the defendant has pleaded not guilty to the charge. At the end of the trial, you will decide whether the prosecution has proved the charge beyond a reasonable doubt. When I finish with these initial instructions, the prosecutor and the defense counsel will make opening statements. An opening statement is a summary of what the lawyer expects the evidence will show. After the opening statements, you'll hear testimony from various witnesses. The evidence may also include documents and other things. The prosecution will call witnesses first, then the defendant will have a chance to call additional witnesses if he chooses to do so. Both sides may question each witness. Again, you must remember the defendant is presumed to be innocent and has absolutely no obligation to call or question witnesses or to present any evidence at all. After you see and hear all the evidence, each side will make closing arguments to summarize the evidence and to suggest conclusions you may reach based on the evidence and the law. The lawyer's opening statements and closing arguments may help you make sense of the evidence you hear and see during the trial, but the openings and closings are not evidence. At the end of the trial, I'll instruct you in detail on the legal rules you must apply in deciding this case. You will then discuss the case in private and work together as a jury to reach a verdict. Now, my job as the judge in this case is to make sure the case is tried fairly, efficiently, and according to the law. I must make sure that you hear and see only evidence that is allowed under our rules of evidence. Those rules determine what evidence the lawyers may and may not present to you. The purpose of these rules is to make sure that what you see and hear in this trial is relevant to the case and appropriate for you to consider. If one of the lawyers says objection, that means the lawyer thinks that a particular answer or exhibit violates the rules of evidence. If I am not persuaded by the objection, I will say overruled. That means that the witness may answer the question, or the other party may show you the exhibit, and you may consider the answer or exhibit as evidence. If I instead say sustained, that means the witness may not answer the question, or the party may not show you the exhibit, because under our rules, you may not consider the answer or exhibit. If I sustain an objection, you may not talk about or try to guess what the evidence might have been. There may be times when I instruct you to disregard something or allow what we call a motion to strike something that you have already heard or seen. If that happens, that means that the testimony or exhibit I tell you to disregard or that I strike is not evidence and you may not consider it. As the judge in this case, I must also explain the law to you. At the end of the trial, I'll give you detailed instructions about the law you must follow in order to decide this case. I'll give you those instructions orally, and we'll also give you written copies to read while we work together to reach a verdict in this case. The lawyers have important roles in this trial. Their job is to bring to your attention the evidence and arguments that best supports their position. They may also object to evidence offered by the other side, as I just discussed with you. Please do not hold it against the lawyers if they make an objection. The lawyers have to let me know when there is a potential issue about whether you may see, hear, or consider something. You, as the jurors, have the most important role in this trial. After you've heard and seen all of the evidence, you will decide who and what to believe and whether the prosecution has proved that the defendant is guilty of the crime charged based on the legal principles that I will explain to you. You must decide this case based only on the evidence you see and hear during this trial and on my instructions and the law. You may not decide this case based on suspicion, guesswork, or speculation. The evidence consists of the testimony of witnesses, as you recall it, and any documents or other things that become exhibits. Other things you will see and hear during the trial are not evidence. For example, the attorney's opening statements and closing arguments are not evidence, and the questions the attorneys ask are not evidence either. A witness's answers are evidence, but a lawyer's questions are not. Now, a very important part of your job as jurors is to decide who and what to believe. Whether testimony is contradicted or not, it is up to you to decide whether you believe it. You may believe everything a witness says, part of it, or none of it. The same is true of each exhibit. You must decide whether you believe what it shows or not. I have no opinion about who or what you should believe or about how you should decide this case. So please don't take anything I say or do during the trial to suggest to you what to believe or how to decide this case. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, or any other personal characteristic. You've agreed to be fair, and I'm sure that you want to be fair, but that's not always easy. Let me share a few strategies. Slow down. Do not rush any decision. Keep an open mind as you listen to the evidence. Also, as you listen to testimony about the people involved in this case, consider those people as individuals rather than as members of any particular group. All we ask is that you, individually and as a group, do your best to resolve this case based on the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, there are certain legal rules that you must follow in this case. I'll discuss them in more detail at the end of the trial. But here are some key things you should know from the beginning. Now, as I told you during the jury selection process, every person who is accused of a crime is presumed to be innocent of that crime. The defendant is presumed innocent of the charge in this case. That means you must consider him to be innocent now and must still consider him to be innocent at the end of the trial unless the prosecution has proved, beyond a reasonable doubt, through evidence presented during the trial, that the defendant committed the crime charged. I'll explain what I mean by reasonable doubt in just a moment. The defendant does not have to do anything to convince you that he is innocent. He does not have to explain anything. He does not have to testify. He does not have to call or question witnesses or provide any evidence at all, because you must presume that he is innocent. Instead, it is up to the Commonwealth to prove the charge against the defendant beyond a reasonable doubt. This burden of proof never shifts to the defendant. At the end of the trial, after you've heard and seen all of the evidence, you'll deliberate with each other, meaning you will discuss the evidence and decide on your verdict. If you have a reasonable doubt about the defendant's guilt, then your verdict must be not guilty. You may find the defendant guilty of a charge only if all the deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. As you heard, the defendant is charged with murder. I'll give you a full instruction on murder at the end of the trial. At the end of the trial, when you meet in private to deliberate, you'll have all the exhibits with you. We cannot provide you with transcripts of any witness's testimony, however, so you'll have to rely on your memory of what each witness tells you. You may take notes during the trial if you wish. Our court officers will give you a notebook or a notepad and a pen or a pencil. Some jurors find it helpful to take notes while listening to the evidence. It may help them to focus on the testimony and remember what the witnesses said. Some of you may not want to take notes, which is fine. Whether you take notes is entirely up to you. Whether you take notes or not, you need to pay close attention to each witness and what they say. In deciding who and what to believe, you should watch and listen to each witness carefully. Think about whether the witness seems believable, whether the witness's memory seems reliable, and anything else about how the witness testifies and what the witness says that helps you decide whether and how much to believe the witness. When you deliberate at the end of the trial, remember that it is your memory that counts. Your notes may help jog your memory about what a witness said, but they are not a substitute for what you or the other jurors remember about the testimony. Do not assume that because you or another juror wrote something down, that it is more accurate than you or another juror's memory of what the witness actually said. Your notes are confidential. No one, including me, will read them. The court officers will collect your notebooks and pens at the end of each trial day and keep them safe until they are returned to you the next morning. When the trial is over, the court officer will destroy the notes. Now, if you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at about 11 a.m., but if you need a break at any other time, just raise your hand or let a court officer know, and we'll take a break. Also, we want Please know, that is not to distract you. It is merely to make sure that we keep the many other cases in this building moving forward, so don't pay any attention to it. If you need to communicate with me during the trial, please let a court officer know or give the court officer a note to bring to me. Finally, there are a few things that you need to do and other things that you must not do. This case with other jurors until you start your formal deliberations at the end of the trial. This is in the middle of the trial. Do not talk or communicate with anyone else about this case until after you reach and deliver your verdict and I tell you that you have completed your jury service. This is because you have to decide this case based solely on the evidence presented in this courtroom and must not consider other information or opinions. When I say that you may not communicate with anyone about this case before you've reached a verdict, that means you may not do so in any way, including through a cell phone or other device. So until you reach a verdict, you may not text, chat, email, tweet, blog, or post anything about the case using social media, other electronic media, or anything else. You have to wait until the trial is over and you've reached a verdict before you say anything about this case to anyone else. You may not talk to the lawyers, the parties, or the witnesses during the trial. If the attorneys or other trial participants see you and turn away, they are not being rude. They are simply following the rule that they may not speak with you during the trial. During this trial, you must not read, watch, or listen to anything about this case that may appear in any news media, social media, or any other source. If there's any press or other coverage about this case, you must ignore it. Do not do any research or investigation about the case online or in any other way, or have anyone else do that for you. Do not visit any place mentioned during the trial. Do not Google or search for the names of anyone participating in this case or anything else about it. Again, this is because you must decide this case based solely on the evidence in the law presented to you in this courtroom. The instructions I just gave to you apply not only to this case, but to the case starting in this courthouse next week, the Commonwealth of Massachusetts versus Karen Reed. That case has absolutely nothing to do with your duty to determine the facts in this case, and please do not let it distract you in any way. Now, the rules that I explained are very important. I'm going to keep reminding you of them and ask you if you've been able to comply with them. If anything happens that seems to be inconsistent with these rules, please do not discuss it with your fellow jurors. Instead, let a court officer know, and I will speak with you privately. Now, I know that you will try this case according to the oath that you just took as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath and approach this case with an open mind and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a fair and a just verdict. Okay, thank you, jurors. It's now time for opening statements, so I'm going to turn it over to Ms. Beatty.
Thank you, Your Honor.